When the defense gets an attitude, drop docs like they're hot, and Nick McClelland did. So today, quite a lot of documents dropped today. So we're going to start out with the first one that I'm going to read, which is the motion for leave of court to subpoena third-party records. Comes now the state of Indiana by Nicholas C. McClelland, prosecuting attorney for the 74th Judicial Circuit, and moves this court for an order for Rushville Police Department. Attention, Chief Craig Tucker, 270 West 15th Street, Rushville, Indiana, to produce to the Carroll County Prosecutor's Office, attention Nicholas McClelland, and it gives his address, any and all employee records for Todd Click associated with his employment at Rushville Police Department. While working the Delphi investigation, Carroll County Sheriff's Department Detective Tony Liggett developed information that Richard Allen was involved in the murders of Victim 1 and Victim 2. During the investigation, then Rushville Assistant Police Chief Toddy Click, his name is Todd, but this reads Toddy, participated in following on leads and interviewing parties associated with those leads. The defense had listed Todd Click as a witness they intend to call during their case in chief to express his belief that other people were involved in this crime. The state believes that Todd Click has employee records that show a Brady-Gilio violation that could call into question his credibility as a witness. This violation could also call into question the veracity of his testimony. The state is requesting the employee mental records, yes, I read it correctly, for Todd Click, he's Todd now, for his employment at Rushville Police Department, specified in the attached subpoena duces tecum, I don't know if I'm spelling that right, and or request for production of documents and records to a non-party. This request is made for the purpose of preparing for trial in this matter. The state believes that Todd Click will be a witness called by the defense to support their theory of the case. The state believes the employment records of Todd Click are relevant and would assist the state in preparing for trial. The state of Indiana has contacted the defense in this case, and the defense does not object to the subpoena and would waive the 15-day notice requirement. Wherefore, the state of Indiana by Nicholas C. McClelland, prosecuting attorney for the 74th Judicial Circuit, respectfully prays that this court review the attached subpoena and then order production of said records and such other relief as is just and proper in the premises. Okay.
Okay, couple thoughts on that. First of all, Nick McClelland did not write this. He might have had
Maybe Toddy?
his son or daughter write it, because I'm sure they can write much better than he does, but he definitely did not write that. And secondly, of course, the defense is going to say, sure, get all the records you want. This guy's, I've seen his resume, and it's pretty much impeccable.
He seems pretty legit to me.
He is totally legit, so they're probably like, yeah, go for it.
Maybe in our next live we should drink hot toddies instead of wine.
And hot toddies. What the heck was that all about?
In celebration of Nick McClelland, we could drink some hot toddies.
Oh,
okay.
Now this case just never ceases to amaze.
And you know what's interesting, and I'm only gonna make this comment because I know we gotta get back to Delphi. Koberger is starting to turn into this. But anyway, okay.
They're probably watching this. They're like, let's go this route because it's working.
Then there is the subpoena, and I cannot pronounce the rest of it because I don't speak Latin. This was to the Rushville Police Department. Attention, Chief Craig Tucker. Regarding Richard Allen. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland, pursuant to Rule 2 of the Indiana Trial Rules of Trial of Criminal Procedure, requests that the following documents and records be produced for the Carroll County prosecuting attorney Nicholas C. McClelland, it gives his address, within 30 days from the date of service of this request for production of documents and records to a non-party. Which is really interesting because the case is going to trial in less than 30 days. Okay. Definitions. The term document includes all margin comments, handwritten notes, date of receipt stamps, and notations of any kind appearing on any document. The term document includes all files and data stored on computer disks or hard drives, all files and data stored on any computer databases. For each document produced, identify the corresponding request. If you claim any information sought herein is privileged in whole or in part, object to any form of any request, or believe that any document would be excluded from production to the state, regardless of its relevance, state the reasons for said objection or ground of exclusion. Identify with particularity each document for which you claim a privilege, including the date of the document, the person who prepared the document, the person to whom the document was directed, the substance of the document, and the reason you believe the document is privileged. And then he gives them a bunch of instructions, but I will read the most important instruction that basically sums up all the other instructions. You are required to keep this subpoena and the information contained therein confidential. This subpoena, which is really interesting because we're reading it. This subpoena and the information listed herein is not to be released to the public and should be kept confidential. Any release of this information will be in direct violation of a court order. I'm assuming that
So I'm assuming whatever
they
the
write.
subpoena.
But it did look funny there,
It does,
right?
yeah, it
Okay.
does, it's worded.
And then
Kinda
it
weird.
outlines the documents and records to be produced. Any employee records for former Assistant Chief Todd Click for his employment with the Rushville Police Department. Any other documents, records, notes, videos, and/or writings that make up Todd Click's employment file while being employed by the Rushville Police Department. Oh, you need me, Nick McClelland, to rewrite your documents. Submitted under my hand as counsel of record pursuant to TR2 on this 23rd day of April 2024. So there's that. So that basically tells them what they want and how to do it, correct?
Yeah.
Okay. Then there was a certificate of service. I hereby certify that service of a true and complete copy of the above and foregoing pleading or paper was made upon the following parties and filed with the Carroll Circuit Court by depositing this same in the United States mail in an envelope properly addressed with sufficient postage affixed this 23rd day of April 2024. So that's basically like I'm mailing it to, I'm assuming?
Yeah, but we're assuming that Nick actually addressed it correctly, because he's, which is kind of a stretch with him. We really can't be sure.
Let's see,
It might,
who is this going
might end
to?
up in our mailbox, actually.
This is going to who?
Rushville Police Department.
Okay, but maybe he'll get the guy's name wrong? Okay.
Obviously, I don't have a lot of faith in Nick McClelland.
So that is, okay, so now there's another subpoena. This is the second subpoena to the Rushville Police Department. Pursuant to Rule 2 of the Indiana Rules of Criminal Procedure, you are hereby directed to produce the following to counsel for the Carroll County Prosecutor Nicholas C. McClelland at 101 West Main Street. It gives the address. All documents requested in the accompanying request for production of documents to a non-party, an executed affidavit of custodian or records enclosed, submitted under my hand as counsel of record. 23. And then this basically is how, this is for the person who has the records to basically sign that they're legit.
Can I ask you a question?
Sure.
And this is a legitimate question. What is the start date of the trial?
May 13th, they'll start the jury selection.
And what's the date today?
April 23rd, it says it right on the dock.
And it says within 30 days. So
That's what I said. I said within
So
30
why-
days, it's not.
why would they not make it within, before the trial starts?
Do they know something we don't know and the trial's gonna be further delayed?
No, you keep saying that and I don't believe it. I don't believe it for a second.
My girl Anya from the murder sheet says it's not going on the 13th.
I know, you and Anya are
Anya and I are like this.
yelling into the wind.
Affidavit, okay, so there's another one. Affidavit of custodian of records, and this is gonna be the last of my part. So basically, this is for whoever gets the records has to sign. And they have to sign, no name, because it has no name, on behalf of the Rushville Police Department, being first duly sworn upon my oath, state the following. I am the custodian of records attached hereto. The copies of the records for which this certification is made and which are attached hereto are true and accurate reproductions of the original records maintained in my files. I'm assuming this is just CYA stuff.
Yeah.
The records
Absolutely.
reflect memoranda, reports, records, and data compilations that were made at or near the time of the occurrence of the matter set forth in each of the records, or from information transmitted by a person with knowledge of the matter set forth. The memoranda, reports, records, and data compilations reflected are kept in the course of my regularly conducted business activity, and it is my regular practice to make the memoranda, report, record, or data compilation. I am providing this affidavit as the custodian of records pursuant to Rule 803 of the Indiana Rules of Evidence. I do hereby swear and affirm under the penalties of perjury that the attached documents are true. And then it gives a bunch of things for whoever has the records to sign, which you can't see on my phone, but it basically says signature, printed name, title, name of entity, date.
So it's probably either a secretary or maybe a deputy, but probably just like the office secretary, I would imagine, who has control of the records and whatever else they have in there.
So that's the first bunch of documents that dropped today.
That means it's my turn?
If you'd like to read them in their entirety, they're posted on Reddit. Anybody who is looking for all these documents and things like that, the best source I found is the subreddit titled Delphi Trial, and there's also a subreddit titled Delphi Docs, and you can sign up for the notifications from those two subreddits, and then you know when the docs drop, because this is what happens to me. I mean, what happens to me.
What happens to
This is how I sign up for the notifications. So this is kind of how it goes down. I'll explain this real quick before we get into more serious stuff. So I get the notification. I'm usually sitting in a class as the inclusion teacher. I see the notification, I pull it up, I freak out, I get all excited, I text him, and then I print it out and I run to pick it up. That's pretty much how it goes.
All right, so now I do know it's my turn because Mary was nice enough to highlight my part in blue, and hers is in pink, so that's how I know this is mine.
Yours has a lot of case law, so I don't know if you want to read all the case law, but.
I will see what we have here. All right, so this is the state's objection to defendant's motion to suppress filed April 11, 2024. So this is this is the state filing their motion to suppress their answer to the defendant's motion to suppress. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully objects to the defendant's motion to suppress filed April 11, 2024 and would ask the court to deny the same. In support of said motion, the state would ask the court to consider the following. 1. That the state has provided the defense with statements of Richard Allen. Those statements include phone calls made by Richard Allen to his wife and his mother, and statements that he had made to Indiana Department of Corrections staff and inmates. The statements made to the Indiana State Department of Corrections staff and inmates, referred to as suicide companions, consist of statements on door sheets. These door sheets are forms provided by the Indiana Department of Corrections for monitoring the behaviors and statements of Richard Allen at a frequency determined necessary by mental health personnel. So just real quick on that, as we know, Richard Allen was assigned people because they thought he was suicidal. The defense says he wasn't. But so he was assigned people to sit outside of his cell, essentially, basically 24/7. So, in the court, and these people were mostly inmates, and we're not talking, low-level inmates. We're talking, pretty serious offenders. So they were sitting outside of his jail cell, and I guess just, during the normal course of conversation, they were either talking to him and he was telling them stuff, they were making it up. We really have no way of knowing because it wasn't recorded. And then they would go and tell their family members, tell their, on the phone.
Here's my
their phone
problem.
calls.
You're suicidal, you're accused of the murders of 2 young girls, you're in a maximum security prison, and they assign you inmates who probably want to kill you because
Yes.
of what you're accused of. It makes no sense to me whatsoever.
But that's what they did. So that's part one. So the second part, that the state has identified and provided the names of all suicide companions, which the state intends to call as witnesses for confessions and relevant statements against his own interest, which includes 16 correctional officers, 8 inmate companions, Warden Gallipew, mental health personnel, and Indiana State police officers. The admissibility of a confession is controlled by determining the totality of the circumstances, whether the confession was made voluntarily and was not induced by violence, threats, or other improper influences that overcame the defendant's free will. And then they state some case law that they're referring to, Carter v. State, Wilcoxon v. State, for example. And the same test determines whether Miranda rights were voluntarily waived, and again, more case law. Thus, these voluntariness of a defendant's waiver of rights is judged by the totality of the circumstances. An express written or oral waiver of rights is not necessary to establish a waiver of Miranda rights. And then they state more case law. And then part 4 of this, the Fifth Amendment's privilege against self-incrimination applies to the states through the 14th Amendment. When a defendant challenges the voluntariness of a statement under the United States Constitution, the state must prove by a preponderance of the evidence that the statement was voluntarily given. In addition, Indiana Constitution Article 1, Section 14 provides that no person in any criminal prosecution shall be compelled to testify against himself. The Indiana Constitution requires the state to prove beyond a reasonable doubt that the defendant voluntarily waived his rights and that he voluntarily gave his statement. That could have been written by either prosecution or defense, the way I'm reading that. That sort of, I mean, I understand that he's stating case law and he's gone back to the case law, but that could really apply to either side.
I don't understand where they do this. I've never heard of this done before. I mean, like I said, all the Watts report, which would be a similar type of situation before he was placed, was all by the guards. It's just crazy.
All right, so part 5. The self-incrimination clause of the Fifth Amendment protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature. And then again, they cite more state law, Curry v. State. In order to be testimonial, an accused communication must itself explicitly or implicitly relate a factual assertion of or disclose information. Absent interrogation, there is no infringement of the Fifth Amendment rights identified in the Miranda and no occasion to determine whether there has been a valid waiver. The term interrogation under Miranda refers not only to express questioning, but also to any words or actions of the part of police, other than those normally attendant to arrest and custody, and the police should know are reasonably likely to elicit an incriminating response from the suspect. Since police cannot be held accountable for the unforeseen result of their words and actions, the definition or interrogation can extend only to words or actions on the part of the police officers that they should have known were reasonably likely to elicit an incriminating response.
And then I keep hearing this too when I'm like listening to podcasts and stuff about Delphi. Basically, they don't have to read you your rights unless you're going to be taken in for the crime, from what I'm being told. But I thought it was whenever you spoke to them.
No, I think I don't think they have to read you your rights until they place you under arrest or take you into custody. So in other words, I believe, and again, I'm not a lawyer, so don't quote me on this. But if they are just questioning you,
right,
as long as you are able to walk away, like as long as you're not in custody of any kind, I don't think they have to read you Miranda.
Right.
Just like in the Nicole Kessinger interviews,
right, that's true.
They didn't have to read Miranda
right,
because she was able to get up and walk away whenever she wanted to.
Right.
But the second they take you into custody, I think it's that point when they have to read Miranda. But,
so that would make sense in the Chad Dorman case because he admitted and then they arrested him right at the scene. So then when they spoke to him, they would okay, that makes sense then.
So I'm pretty sure as soon as the cuffs go on, they have to read Miranda. All right, part 7. That the defendant is being held in pretrial detention for his safety pursuant to court order, inmates of the PLUS program and subsequently corrections officers at the IDOC holding facilities have been assigned to observe Richard Allen and record his behaviors. which has including documenting statements by Richard Allen. That the assignment of correctional officers to replace inmate companions coincided with Richard Allen being provided with legal documents for his case. Therefore, it was determined no longer appropriate for inmates to provide companion services due to the gag order and the discovery protective order. And I think what happened there was they found out that the inmates were just, blabbing to their family members and friends,
That's what it had
so
said
they
in
pulled
another
them out of there.
document, Yes.
Part 8. That the defendant alleges all his statements subsequent to arrest should be suppressed for the reason they are involuntary due to the condition of his pretrial detention, which they characterize as illegal coercion, either psychological or physical, in violation of his constitutional rights. Part 9. Statements by Richard Allen which the defense seeks to suppress are unsolicited and voluntary, like those in Say vs. State, where defendant made unsolicited statements while he was being moved from one part of the jail to another. Such statements were properly admitted into evidence. Part 10. The defense has alleged that physical coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. The defense has also alleged that psychological coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. Part 11. That the defendant has not alleged that any of these statements are the result of interrogation by law enforcement while in custody, and the state would assert that Richard Allen is not being interrogated by law enforcement or any agent of the state during his pretrial detention regarding the charges pending herein or regarding any other criminal activity. All right, now that's interesting. That's actually, to me, from what I've read so far, I think this is the most poignant point of his argument.
Yes.
Because you can
Yes,
sort
I
of look
agree.
at it like,
Yes.
and law enforcement will do this. If somebody's in jail, they will send somebody in, as a cellmate or whatever, to try to elicit information out of them, and that can be admissible if they're just talking back and forth.
Right.
If it's another inmate
Right.
talking to him in their cell. So this is actually, I actually think Nick did a good job on this.
Well, that's a little bit different if he's in your cell just hanging with you versus,
But
being
then
stationed
if you
outside.
really, all right, so let's think about it. Let's take it out a little bit
No,
further.
if
Is
you-
there a difference between him being in his cell and an inmate being right outside his cell?
Yes, I think there is a difference. I think the difference is the level of intimacy.
Okay.
Like, if somebody's in your cell, you're going to be more apt to confess to them because you feel like there's a level of intimacy with the person just there hanging out with you
Right.
one-on-one versus outside monitoring you and writing things down. I would think he would be more apt to confess under the circumstance of the person being in the cell hanging out with him. You know what I mean? And more so if it was a one-on-one situation than
Well, I'm not a fan of Nick McClelland, but I think to me, that's a really good point. All right, number 12. That case law on application of the protections of the Fifth Amendment indicates that absent interrogation by law enforcement or an agent of the state, the defense does not have a basis to challenge the admissibility of voluntary statements made by Richard Allen. The state acknowledges its burden to show beyond a reasonable doubt that the statement was not obtained in violation of the Indiana Constitution or by a preponderance of the evidence that the statement was not obtained in violation of the United States Constitution. However, the state does not believe the constitutional protections allow for the defendant to allege that all statements during pretrial detention are the result of coercion directed against him. This posture requires the court to begin with an assumption that the pretrial detention in IDOC, by its very nature, is coercive interrogation by a state actor, and thereby shift the burden to the state to present testimony to refute illegal coercion for every statement made by the defendant. Part 14. The defendant is making a blanket argument that all statements by Richard Allen are the result of improper influences based on the defendant's mental state without having to address each statement and its unique circumstances. The defense argument ignores the case law regarding application of their cited constitutional protections by skipping over the threshold of showing all alleging interrogation by law enforcement or their agents. The defense motion expects to court, I think that should say the defense motion expects the court to accept and it's wrong in here. I actually read it
Expects to
right.
court, yes, it looks like they're going to court
Yes.
the inmates,
The
like they're going to
defen-
take them on dates.
The defense motion expects the court to accept all inmates, employees, and third-party medical or mental health personnel are acting as agents of the state, specifically law enforcement, with the purpose of illegally coercing statements from Richard Allen for his prosecution. The allegations and assumptions are absurd, unfounded, not supported by the motion filed by any facts or evidence. The motion to suppress all of Richard Allen's statements is another attempt by the defense to derail this case with conspiracy theories and inflame the public to believe the government has unjustly pursued charges against Richard Allen. Part 15. The state requests that the defense be required to identify the specific statements of Richard Allen that were illegally coerced and identify the state actor whose conduct supports the allegations of coercion and describes the conduct they believe to be either physically or psychologically coercive before the state is required to respond for further analysis by the court. Part 16. In the absence of specific allegations by the defendant as to each statement against his interest that is involuntary as a result of law enforcement interrogation, the state asserts that the defendant has not sufficiently identified statements subject to a motion to suppress. Wherefore, the state requests the court deny defendant's motion to suppress statements filed on April 11th, 2024 as failing to state a claim for relief under the 4th, 5th, and 6th Amendments of the United States Constitution and Article 1, Sections 12, 13, and 14 of the Indiana Constitution, absent a more specific statement setting forth with specificity the statements obtained during custodial interrogation by law enforcement or their agent, and identifying the conduct by such state actor that would be psychological or physical coercion, illegally and knowingly directed against Richard Allen for the purpose of inducing confessions or statements against his own interest. Bravo, Nick McClelland.
He
This is actually
finally
really good.
pulls out a document that's written well, there's no toddies in it, and he actually cites case law.
Yeah, this was
But
actually.
did he write it,
I-
or did Stacy Beaner write it?
Doesn't matter. This was impressive. So I give him props, and I have said from the very beginning that those statements are going to come back and bite him in the ass.
But,
So the defense really has their job cut out for them to dissuade the jury to disregard those statements.
okay,
It's
so
not gonna be an easy
let's
thing.
do a poll of us and all our people in the chat, if you guys could humor us. You're on the jury. You hear all the evidence of how Richard Allen is being kept. Okay? You hear he's confessed. That's all you got. You've got how he's being kept, he's confessed, no other evidence. What do you think?
That's not an easy yes or no answer there.
Uh-huh.
For me, anyway,
Mhm.
first of all, the inmates, I would just disregard all of that. I would not believe a word that comes out of their mouth.
And
They're
that's
probably
what they
being,
say will
they're
happen.
probably being offered,
They say their testimony
you know,
never stands up
perks
in
and
court,
everything,
right?
anything else they can get in prison. The law enforcement officers that have been identified as wearing the Odin patches, getting the Odin tattoos, I don't think I would believe them either. But from what I understand, there's a lot of different people who have this. So it would really come down to, for me, who those other people are, what their background is, and then what were the circumstances for the confessions.
Okay, but let's think about the one to his wife. What do you think about that?
To me, and I've told you this from the very beginning, for me anyway, I would not take that at face value. Only because I am sort of believing their theory that he was intimidated in prison and that these guards and these officers were intimidating him, and I can easily see it happening. And it's not, and even we've seen evidence of where there was videotapes where there's people following him around, they're recording him, they're watching everything. think about it, it is not that hard to get into the dude's ear at any point and make a threat. And the fact that every time he got on the phone to his wife or his mother, is everybody okay? Is everything okay?
But like I
It's
said,
very telling to
that
me
could
that he
also
may
have
have
been
threatened.
paranoid. That could also
It
have been
very well because of
paranoia.
his mental
It
condition.
could have been psychosis.
Mm-hmm.
I think that no matter what happens with the way he was being kept, which this is a problem, if he had been being kept at the county jail and did this, he's guilty, in my opinion. But what's going to happen is that they're going to, the defense, hopefully if they could afford the, because
The experts.
it's not like I want Richard Allen to get his experts desperately, I mean, hopefully, but I believe in a fair trial, and if he were my family member, I would want him to have a fair trial, and if Libby and Abby were my family members, I would want them to get the right guy.
Exactly. I would want to make sure it's the right guy. And I've said all along, I'm on the fence. I don't know how to look at this.
Curtis made a good point.
In my
Curtis
head, okay, go ahead.
Yeah, listen to Curtis before you keep talking. If he gives details that he had not, that no one read about in the discovery while talking to his wife, he wouldn't be more than 50%.
Absolutely,
Yeah.
yes. If there are
Right,
specific
if it's detailed.
details.
But
yes.
now what I've heard over the summer when this happened was he just said, I killed them girls. That's all that
Yeah.
I have heard he said.
Right.
So take it for what it's worth. I'm sure they didn't report everything in the summer, but in the summer is when he made the confessions. Because remember I said to you over the summer, he's going to be,
Yeah.
this is never going to trial and he's guilty.
Yeah.
I thought as soon as they reported he confessed that it was, it was a done deal.
Right.
So.
Yeah, and I've said all along, I'm on the fence. I always say, and not just in this case, in any case, we don't know what we don't know until the trial.
Right.
We're not going to have all the information. They have the information. It's not our right to know the information until they present it. And at that point, then you can make a decision one way or the other. But just going by what evidence I've seen, it's hard for me to believe that
Yes.
and maybe he was involved. But even if he was involved, it's hard for me to believe that only him and just him and nobody else helped him with this. Because I am convinced that more than one person did this just due to the circumstances of the crime. So, again, I'm gonna hold final judgment until the trial because,
Joni
again...
said the Franks is what changed her to not guilty, and we agree, when we heard it, not that we agree that he's not guilty, but we agree that the Franks memorandum gives a very compelling argument that would sway at least one juror.
Yeah, and that's what we've always said. You only need to get one juror. And the fact that defense that they're going to be presenting really is not their defense. It's law enforcement's defense. Law enforcement came up with this. Law enforcement pursued this. They had that Purdue professor that collaborated with it.
Right.
So
Well, there's also the timeline.
It's different than just the defense saying, "Oh, this could have happened, and this is our theory." No, this is what law enforcement was working on for years.
Well, there's also the timeline. There's also the location. There's also 2 victims involved. There's that creek they crossed. There's just a lot of other factors here that make me believe that he couldn't have done it alone.
No, and even law enforcement doesn't think that it was done by one person.
Right.
So it's going to be tough.
And Curtis is right. Curtis said no one really has any established time of death. That really makes the case difficult.
Yeah.
And that's the timeline, right. And another problem with this case is, unless they've got some DNA, forensically they do not have good evidence.
But I just hope that...
Ballistics doesn't hold up in court really well. Witness testimony doesn't hold up in court very well, and your witnesses didn't agree on the PCA. Hopefully they have other things where they agreed if he is the guy. And then your witnesses are half the inmates at the correctional center, or like a bunch of these dudes in the town that look like they're like, I hate to say it, but they look like white supremacists.
Mm-hmm.
If they're in this group and this Odin group and they're hanging out with MAGA, let's just call them what they are, right? I hate to say that, but and this is our opinion. Once again, we're going to just state this is our opinion based on our own research. Do your own research, form your own opinion. We are not trying to tell anybody what's up here.
No, not at all. And we are waiting till the end of the trial to really make a final decision, truthfully.
I agree, Joni. I don't think he fits the profile either. I think they're gonna
We've
have
talked about that
somebody, right,
before.
you're gonna have a career criminal here who did, unless it's a ritual sacrifice, you know? So if anybody has any more questions, post them in the chat. If not, we're gonna talk about the wine, and I guess our live's over, huh? We read the docs.
We did read the doc,
We did
and
what
we
we
are
came
drinking
to
some
do.
wine, even though it's a Tuesday night. Mary's taking off of work tomorrow, so that's why she's drinking.
Yes,
For me,
I
it
have-
doesn't matter.
I have a
If
medical
if
appointment,
I'm
which-
working or not working, it doesn't matter.
I have
I'll
a
drink.
medical appointment, which is probably good that I'm drinking, having drink tonight. Oh well.
Alright, so we're drinking actually a very good Riesling. What'd you think of
Wagner is
this?
a great winery.
So this is Wagner Vineyards up in the Finger Lakes. For some reason, I can't remember this vineyard. The wine is
It's
fantastic,
near Napa.
and I know that one year we went up there. I was on this Riesling kick,
It's near Nap.
so I was like,
With
we
the
got to find
cats?
the best Riesling in.
It's near Nap with the cats?
Yes,
Yes, okay.
yeah. So, but this Riesling is just fantastic. It's
So Joni's got a
nice and
question
dry.
after Pete talks about the Riesling. Do you think, in your opinion, that Ron Logan had knowledge of the crime even if he wasn't involved?
Yes.
Ron Logan was a bad dude, let's put it that way. And it was on his property, right? So he seems to me like the kind of guy who'd be like, get off my lawn and
Oh, yeah.
freak out. So if something went down on his property, but it could have been, who knows?
My problem with this whole thing is that they
Yay,
right,
Barbara! Oh, this wine's so good.
right after the murders, they actually went right after these people. I mean, within days, they had Brad Holder, they had Elvis Fields, they had Ron Logan, they had all the cast of characters. They were zeroed in on them, and then all of a sudden it just went away, which is very strange to me. And they were never revisited by Unified Command. Now, the Todd Click and Ferenczi and them, they kept going down that road. But the fact that, why did they zero in on them almost immediately? That's never been explained to me.
This trial is going to be a hootenanny, let me tell you.
Yes, it is.
And sadly, like we said, it's not televised. Everyone's begging her. It ain't happening.
It's not going to happen.
And then
There's
a lot
no
of people
way.
said, why don't they stream it like Idaho does? You know, because Idaho Judge is going to stream his own, and then they're streaming Chad Daybell. Not happening.
Judge Gull does not want this televised. She does not want people to see this. I think she's afraid of what's going to happen in there, and she just doesn't want the visuals. So.
Absolutely, Joni. Yes, we were talking about that in our last live. Ferenczi dies, and then they stop the investigation.
Mm-hmm.
WTF was that, people? Like, really? Thanks for joining us, Curtis. We appreciate you. Catch us in the next live.
Appreciate everybody joining us.
And Kylie, we would love to go to the Arizona wineries. I'm retiring
Ooh.
in 3 years, and we're getting an RV. We don't get to travel a lot now because we have 4 rescue dogs that I think everybody needs to meet in the next
Yes.
live we do.
Yeah.
And we're going to get an RV, and we're going everywhere. Our dogs are all getting up there in years, so I'm thinking in a few years we might be down to like maybe 2 little guys that we could just
That we
hop
just
in the
throw an
RV.
and
Yeah,
go.
but our
Absolutely.
little guys are not real travelable. They're kind of jerks.
No, really?
Yep.
I never realized that. I thought they were little angels.
I feel for the jury too, but you know, some of these people just live for this. You know, the one juror in the Lori Vallow trial, the Lori Vallow Daybell, whatever name she has, she's been married like 15 million times. He's going and watching the whole Chad Daybell trial because he wants the other side of it, and they keep interviewing him on court TV. So a lot of these jurors, or the juror in the Crumley case, they interviewed her all the time.
Mhm.
There was Strawberry Shortcake from good old Scott Peterson's jury. So a lot of these people go on to, well, I wouldn't say be celebrity-ish.
But they
Be
get
D-listers.
some notoriety.
On the D-list. Yes, you will definitely meet the puppies in the next one. There's something.
They are something.
Oh, Joni, you're in Florida. Cool. We really thought about moving to Florida. That's on the agenda. We might go to Florida. We're over the Pennsylvania weather. We can't wait
Yes.
till I can retire. But I have 3 more years teaching, and then I can be done. All right, so we will catch you guys in the next live. We're gonna plan on it for my birthday on Sunday. We're gonna go live and have my birthday celebration with the dogs and whatever comes up in the next couple days.
Yeah.
So we'll post it in the community.
Yeah, definitely.
We'll post
Yep,
when we're gonna
post
go
the
live.
time. Yep.
I think the jury will do what's right. They really, I mean, I was just, we'll end with this. I just got called for jury duty. I didn't get chosen because my friend, my very close friend who I've worked with for like almost 30 years, she got called that day too. And she couldn't hear, and he said, does anybody, there was construction, and they said, does anybody know anybody here? And I raised my hand and said I knew her, and she didn't raise her hand and say she knew me because she couldn't hear him. So she got picked as an alternate and then got COVID and couldn't go to the trial. If it wasn't for her, I probably would have been picked, but anyway. Thank you guys, we appreciate you. Please leave comments, subscribe, watch our content. We're a fledgling channel and we are really trying to make it, so thank you.
Thanks, everybody. See you next time.